Hi students, good evening. This is Professor Bhagyashree Pandey, and today we are going to start with our module 7 to 12. Okay, so I'll be starting with a brief of my introduction. It may be possible that some of you are first time joining for this our live session too. So this is Professor Bhagyashree Pandey, your professor for legal aspects of business, and I'm handling all the HR domain, HR related subjects at our MIT. And apart from that, I'm also pursuing PhD in HR domain itself. I am having approximately 10 years of teaching experience and HR field. Okay. So I want this session to be interactive, even though this live session two covers like total 6 modules in this. In between, I will be posting some poll questions to know that how much concept you have understood. These poll questions will be from the modules only. Okay, and at the end of the session, looking at the time, we'll be also having question and answer session. Okay, so starting with this, in this particular live session too, we'll be covering total 6 modules, right? So sale of goods act, consumer protection, intellectual property rights, then company law, right to information act, and some of the miscellaneous acts. So in all these acts, I will be touching upon some important concepts, or we can say some important provisions out of those acts. So starting with this, and as I said, in the Sale of Goods Act, we'll be touching through some of the important provisions, some meaning, some applicability of the Sale of Goods Act. Under consumer protection, we'll be going through various rights of consumers. What is the consumer protection basically? What kind of protection the consumer, as a consumer, we should get. Then under intellectual property rights, we'll be going through various types like patents, trademarks, geographical indication, and all those under India. Under company law, we'll be going through memorandum of association, articles of association, various types of companies, what is the meaning of prospects and shares under the Company Act. Then under the RTI Act, that is right to information, some important provisions again will be going through. And apart from that, Partnership Act and Competition Act in a brief we are going to see. In Miscellaneous Act, we will be going through minimum wages, information technology, some important provisions of Factories Act, Workmen Compensation, Negotiable Instrument Act, and apart from that, Personal Data Protection Bill will be going through in all these 6 modules. Okay, so shall we start with this?
Okay, ma'am.
Yes, great. So we are going to start with Sale of Goods Act here. So when talking about, yes, so I request all the students to keep all your voices on a mute. Whenever I call, you can talk. Till then, all of you are going to keep your voice on a mute to avoid any disturbances in between. Okay. So meaning of contract of sale. So sell is basically anything, like anything which we do in our day-to-day lives. We sell something, we buy something. So whoever is going to sell, they sell some goods or services to another person, and in return they get a price for that. So here these two parties are involved: the one who is selling and the another one who is receiving those goods and paying a price for that. So in a sale, that is in a contract of sale, there are two parties involved in this contract: the one who is selling and in return getting price for it, and the other one who is receiving goods or services and paying for that. So it's a two-way action, right? Then there are certain, we can say certain descriptions, or we can say differences between what is sale and agreement to sale. So sale happens actually when the transfer of goods or services are going to happen from one place to another place. We can say from seller to the buyer. Agreement to sale is going to happen when certain actions have been done, but certain are going to happen in the future time. So maybe after 10 days, maybe after 15 days, maybe after 6 months, like you get a possession after 6 months once you book your flat. So that is agreement to sale you are doing, right? So sale is, it's immediate action, and in the sale, whatever actions are there, it's performed by both the parties. So the one who is selling, he has done with the selling. Another one who is receiving those goods or services, he has paid for it and he has received it in return. So it's an executed contract when both the parties have done with their transactions. Executory contract is half of the part of that transaction is yet to be done, which will be done in the future time. So that future time will be decided in the agreement by the parties. That, as I said, that future time can be after 10 days, can be after 1 month, can be after 6 months, on 1 year, after 2 years, depending upon the case. So it's an executory contract when some of the parties yet to be done. In the case of sell, if there is any kind of a loss, that loss will be fallen on the part of buyer, as he has already done with all the transactions and the possession is already with him, right? So he has already got a possession of the goods which he has received. In case of agreement to sell, it may happen that that particular party haven't yet received the possession of those goods, and the possession is maybe yet with a seller or with a buyer, right? It may also happen that the seller has transferred goods from him to the buyer. Buyer has paid part payment and part payment is yet to be done. So in that case, the possession is not fully transferred from one place to another place. And hence, if there is any kind of a loss, seller has to bear that loss. Okay. In case of consequences of a breach, so breach is breaking the contract. So if there is a break of the contract, there is obviously a loss which has to be bear by either of the party. So in case of a sell, if seller sues, a seller can sue for a price even though goods are still in a possession of the seller. So it, like, seller has sold goods to buyer, buyer has bought it, but in between buyer has broken the contract. In that case, seller can sue for a price to the buyer even if he has transferred goods from seller to buyer. In case of agreement to sale, seller can only sue for damages but not for a price, because it's still in a position, it's still going on. The complete transaction is not yet done. Half of the transaction is done and half of the transaction is not yet done. So in that sense, seller can only ask for the damages and not for the price. In sale, seller has given everything to buyer and hence he is asking for the price. And agreement to sale, seller, this is a half partially done transaction, that's why seller can ask only for the damages. Insolvency of the seller, if buyer is entitled to receive goods from official assignee or receiver of the goods. Like if whatever transaction has been done between seller and buyer and in between the transaction seller got insolvent, पता नहीं है वो कहाँ पे है, transaction अभी बाकी है, उसने थोड़े goods मुझे दे दिए हैं, थोड़े मुझे पता नहीं है. In that case, buyer is entitled, like buyer is having the right to receive the goods from seller's official assignee or any other receiver of a good. But in case of agreement to sell, buyer has to prove amount it has paid and can only claim for rateable dividend. जो उसने पेमेंट किया है सेलर को, उसको वो प्रूव करना है कि मैंने इतना पेमेंट किया था और उसके रिलेटेड जो डिविडेंड है वही he can claim in this agreement to sell. क्योंकि again the same point कि यहाँ पे transaction complete नहीं. Okay, moving ahead with this. Doctrine of Cavet and Dodd. Now, this is very important concept in the Sale of Goods Act. It is related with the both the parties, like seller as well as a buyer. The meaning of this particular concept is basically like whenever we are going to buy anything in the market physically, or even we are doing any transaction online, it is our responsibility as a buyer to be aware to ask about every details of that product or service. It's our duty to examine all the parameters, to examine the property, to examine all the details of that particular product or service. If we are not asking, then we may be at a fault. जो हमें प्रोडक्ट चाहिए, जो हमारी रिक्वायरमेंट है, उसके तरह वो पर्टिकुलर प्रोडक्ट और सर्विस है कि नहीं. That is our responsibility first to examine. We need to ask, keep asking the questions to the seller कि यहाँ पे ये ऐसे मिलेगा, इसका साइज कितना है, इसका मटेरियल क्या है, इसकी मेजरमेंट्स क्या होगी, ये सब कुछ जो भी है आपको आपके रिक्वायरमेंट के हिसाब से है कि नहीं, वो प्रोडक्ट और सर्विस के रिलेटेड आपको पूछना चाहिए. Another part is obviously from the seller point कि सेलर को आपको ये इन्फॉर्मेशन देनी है. लेकिन ऐसे पॉइंटर्स हो सकते हैं कि आपकी कोई रिक्वायरमेंट है और सेलर को पता ही नहीं है जब तक आप क्वेश्चन पूछ नहीं रहे हो. है ना। कुछ कुछ आपने देखा होगा कि कुछ कुछ बायर ऐसे रहते हैं, बहुत ज्यादा वो पर्टिकुलर रहते हैं, कोई भी अगर चीज खरीदने जाओ तो, कि 3-4 शॉप्स वो देखते हैं, वहां पे चेक करते हैं यहाँ की ऐसी प्राइस क्या है, उसका मटेरियल कैसा है, और उसमें से जाके भी वो लेते ही है, ऐसे भी नहीं। ऑनलाइन तो हमारे पास बहुत सारे ऑप्शन है, लेकिन ऑनलाइन में भी फ्रॉड्स बहुत हो सकते हैं। तो इट्स अवर ड्यूटी एज अ बायर टू बी अवेयर, to ask for all the requirements, to ask and examine everything which you want to do, which you want to possess, and then only go for the purchase. That is this all concept about. So except in the case of fraud, as I said, कि ऐसे हो सकता है कि सेलर की भी ये रिस्पॉन्सिबिलिटी की है, जो आप क्वेश्चंस पूछ रहे हो उसको उसके आंसर देने चाहिए, लेकिन इट मे also happen that if seller itself is a fraud and he is giving you some wrong information, in that case it is not in your hand. Okay, in that case we can sue for that particular seller. If the goods do not suit the purpose, he cannot blame anybody except himself, क्योंकि जो आपका पर्पस था उसके हिसाब से आपने नहीं खरीदा, अपने सेलर को बोला ही नहीं कि मुझे ये इस पर्पस के लिए चाहिए. Okay, this may also happen. So this concept is all about doctrine of Cavet untold, means let the buyer be aware, and buyer should reasonably examine property before purchasing, and it's his responsibility for its condition along with its quality and the need which he is looking for. Moving ahead with this, meaning of or and right of unpaid seller. So the word unpaid seller is itself is saying everything. अनपेड सेलर, जो वही सेलर जिसको अभी तक पेमेंट नहीं गया है. तो पेमेंट कौन कौन से मोड पे नहीं गया है, या तो फुल पेमेंट नहीं गया है, या फिर पार्शियल पेमेंट गया है, और पार्शियली नहीं गया है. इसमें से जो भी हो, दैट particular seller will be called as unpaid seller. Either the whole price is not paid or half of the price has not yet been paid. या फिर चेक दिया है, ठीक है, चेक पे अपने सिग्नेचर करके दिया है, जब तक वो चेक एंडोर्समेंट उसकी नहीं हो जाती है तब तक दैट पर्टिकुलर सेलर इज अनपेड सेलर. आपने चेक दिया है और वो बैंक में जाके बाउंस हो गया, डिसऑनर हो गया, स्टिल दैट सेलर इज अनपेड सेलर. ओके, नाउ to call that particular seller as an unpaid, the unpaid word should be there कि इसको पेमेंट नहीं मिला है, प्राइस नहीं मिली है, और जो भी एक्शन है इट इज रिलेटेड विद द प्राइस ओनली. अभी देर आर certain rights which are related to unpaid seller. The first part is right against goods. अगर that particular seller is unpaid, okay, so he is having the right against goods in these three types: right of a lien, right to stop goods in transit, and right of resale. Right of a lien मतलब you are a seller और किसी बायर ने आपसे कुछ एक ट्रांजैक्शन किया है, उसने आपको बोला है कि 10 तारीख को मैं आपको ये पैसे दे देता हूँ. ठीक है, आज है आज कौन सी तारीख है, 8 तारीख, 8 अप्रैल. आपने आज वेट कर लिया, 9th को वेट कर लिया, 10th को वेट कर लिया, तब तक आपने क्या किया है, यू आर रिटर्निंग द पोजीशन ऑफ दैट गुड्स. ठीक है, 10 तारीख तक आपने वेट किया है. नाउ आई एम गोइंग इमीडिएटली जंपिंग टू द थर्ड राइट ऑफ रीसेल. अगर आपको 10 तारीख को वो बायर ने पेमेंट नहीं किया है, 10 तारीख तक यू हैड अ कॉल विद दैट पर्टिकुलर बायर, और उसने कहा मुझे और 5 दिन दे दो. 15 तारीख तक आपने वेट किया है, फिर भी उसने पेमेंट नहीं किया है. नाउ इन दिस केस, as a unpaid seller, you are having the right to resell those goods to any other buyer who is ready to give your payment on the spot, or maybe within 1 day, 2 day, whatever it is. At least advance payment तो कर दिया. लेकिन वो पिछले वाला जो केस था उसमें वो बायर ने आपको कुछ पेमेंट ही नहीं किया है, सिर्फ गुड्स आपके बुक करके रखे हैं, अभी तक पेमेंट नहीं किया है. ठीक है, और एक पॉइंट है राइट टू स्टॉप गुड्स इन ट्रांसिट. विल कंटिन्यू विद द सिमिलर केस. अभी इसमें क्या हो सकता है, आज है 8 तारीख, उसने हाफ पेमेंट आपको कर दिया है. हाफ पेमेंट ही इज सेइंग कि जब आपका यहाँ से ट्रांजिशन निकल जाएगा, ठीक है, गुड्स यहाँ से निकल जाएंगे, मेरे जगह पे आने तक आई विल पे. दैट पर्टिकुलर रोड इज ऑफ से 2 आवर्स. 2 घंटा हो गए हैं, 2 घंटा होते होते खत्म होने को आए हैं. नाउ दैट पर्टिकुलर ट्रक इज अबाउट टू रीच टू दैट पर्टिकुलर मोमेंट. और टू द प्लेस, फिर भी आपको 2 घंटे में पेमेंट नहीं आया है, as an unpaid seller, again you are having a right to stop that goods in transit, to stop those goods. वो बायर की जगह भी चाहे वो, फिर भी आप उसको स्टॉप कर सकते हो, वो अनलोड नहीं कर सकता जब तक पेमेंट आपका आता नहीं. That is right to stop goods in a transit. Understood? So these are the 3 rights. Moving ahead with this, personal rights of unpaid seller against buyer. Now in this case, he can claim for a price, he can recover the balance amount from the buyer. He can ask for if any kind of damages happened. Seller can sue that for particular damages to the buyer. He can repudiate contract before the date. Like he can cancel if buyer refuses or cancels the contract before the date. 10 तारीख को उसने बोला है पेमेंट करेगा, 10 तारीख से पहले ही 9 तारीख को ही उसने आपसे कॉन्ट्रैक्ट कैंसिल कर दिया, अभी उसमें आपका लॉस हो रहा है. In that case, you can ask for claiming the damages. Okay. Moving ahead with this, these are some of the important concepts. Goods, general goods, which are any kind of movable goods in this. Price is a consideration of money जो हम general transactions करते हैं. This can be actually paid, means you are done with the complete transaction, you have paid for that particular goods completely, or promise to pay. Advance payment में भी अभी किया है, 2 दिन के बाद और करना है आपने बोला है. Okay. Contract of sale, there has to be delivery of goods and in return you are getting a money. Contract of work and materials. Now, in this case, labors and their skills are utilized by another party for any specific purpose in respect of materials supplied by any other party. So, in short, the work and materials used by any other person or skills and labors used for any other person can also be considered as a contract of sale. Then, earnest or money, it means buyer pays seller an amount which acts as a token. Okay. So the buyer is giving some amount to the seller. He is like booking that particular amount of goods with the seller, and he is giving some money as a token or guarantee of goods for the faith. And he is saying that, okay, on this particular date, I will come and will pick up this particular goods.
Excuse me, ma'am. I have some queries. Actually, I want to talk in service customer support, but no one is replying. So can I ask now?
Can we take all your questions at the end, because we need to cover all 6 modules in time? Can we do that?
Sorry, repeat again. What's
I'm saying, can we take all your questions at the end, because we need to cover these 6 modules? Can we take that at the end? Will it be okay?
I already covered. Yeah, I covered.
Okay, okay.
So now I have a question regarding exam. Actually, just exam enrolled.
No. You need to ask about this in the to your ticket management system. This is we are covering about the concept. Okay.
But no one is calling me.
Sir, we need to complete this concepts first. You can just mention it in the ticket management system.
Okay.
Okay. Thank you very much. So moving to the next concept, sell and bailment. Bailment is again this the word may be new to you, but concept is very similar or very familiar to you. So in this case, goods delivered from bailer to bailee, which shall be returned back to bailer when the bailie's purpose is met. So in short, you have kept some goods with one XYZ person for some reason, like you are moving out, like you are going to foreign country for say 1 year, 2 year, and for that particular period you are keeping some XYZ goods with your neighbor. So once you came back, you get those goods back to you once that purpose is finished, once that purpose is met. Sell is generally it's a monetary transaction where you are actually selling the goods, you are transferring possession from one person to another person, and in return you are getting a money from that. So this is the concept. Moving ahead with this. Okay. Now again, these words are very familiar to you. Condition and warranty. So whenever we go for buying or selling any activity, any goods, any services, these 2 words are always attached with that. Condition क्या है, अभी की condition क्या है, इसकी वारंटी कितनी साल की है, 6 महीने की है, 1 साल की है, 5 साल की है, जो भी है. अगर वो वारंटी पीरियड में है और आपको कोई उसको डैमेज हो गया और अगर वो डैमेज उसमें कवर्ड है, देन यू गेट अ रिप्लेसमेंट और उसको जो भी सर्विस है आपको फ्री में करवा देते हैं, है ना। कंडीशन इज बेसिकली कंडीशन ऑफ दैट पर्टिकुलर गुड्स, जो मेंशन किए हुए हैं पर्टिकुलर्स उस प्रोडक्ट के रिलेटेड, एज पर दैट कंडीशन इट शुड बी, दैट इज द मेन पर्पस ऑफ द पर्टिकुलर कॉन्ट्रैक्ट। और कंडीशन के बाद वारंटी आती है। Okay, so in short, warranty is a collateral to the main purpose of the contract. Okay, so this is the kind of assurance कि आपको अच्छी सी सर्विस मिल जाएगी, अगर कोई प्रॉब्लम आ गया तो उसमें आपको रिप्लेसमेंट मिल जाएगा या फिर सर्विस अच्छी मिल जाएगी। ऑल दिस डिटेल्स आर देयर विद द वारंटी। ओके, और एक चीज है कंडीशन के बारे में, आपको जो भी अगर ऑफर दी जा रही है, कोई सर्विस दी जा रही है, तो हमेशा वहां पे लिखा होता है कि कंडीशंस अप्लाई। So this is an essential stipulation. This is something essential attached with any kind of transaction we are doing. If there is a breach in that particular condition, then in that case, this breach of a condition अगर हो गया तो वहां पे वो कॉन्ट्रैक्ट कैंसिल हो जाता है। ओके, मतलब कि आपको ऑफर दिया गया है कि on a purchase of say 5,000 rupees you will get a discount of 20%। ओके, लेकिन अगर कोई एक कस्टमर आप ही के सामने है, वो कस्टमर जो सेल कर रहा है, सेलर है, उसका रिलेटिव है, वो कस्टमर ने सोचो 4,000 की ही परचेस आपके सामने करी और उसको फिर भी 20% डिस्काउंट मिल गया, सो दैट इज अ ब्रीच ऑफ अ कंडीशन। उसमें वो सेलर उसका खुद ही का कॉन्ट्रैक्ट कैंसिल कर रहा है। ओके, सो नाउ इन दैट केस एज अनदर कस्टमर यू विल आस्क फॉर द डैमेजेस। कौन से डैमेजेस यहाँ पे आपके हो रहे हैं? आपने अभी तक पेमेंट भी नहीं किया है, आपको कोई ऑफर भी नहीं मिली है, लेकिन आपके सामने वाले को 4,000 में 20% मिल रहा है और आपको बोला गया है कि 5,000 पे 20% मिलेगा, तो दिस इज योर लॉस इन दैट पर्टिकुलर ऑफर। सो देयर इज अ ब्रीच ऑफ अ कंडीशन। ओके, ट्रीटमेंट क्या मिलेगी ब्रीच ऑफ अ कंडीशन में? इट विल बी ट्रीटेड एज अ ब्रीच ऑफ अ वारंटी, but in case of warranty, breach of a warranty will not be treated as a breach of a condition because warranty बाद में आता है।
Hello, I'm sorry
Yes.
to interrupt. Can you please explain in English? I'm from South
Okay,
India.
okay. Yeah, sure.
Thank you, ma'am.
Okay, yes. So I was talking about breach of a condition. Whenever there is a breach of a condition, as I just mentioned, that if the customer is getting a discount for 4,000 rupees, 20% discount, and another is getting 20% discount on 5,000 rupees purchase, then there is a breach of a condition for the person who may get a discount of 20% on 5,000 rupees. Why? Because he has got a promise from the seller about purchase of 5,000 rupees, then 20%. But another customer who is a relative of the seller is getting some another offer. So in that case, whatever offer as a contract has been made between seller and all the customers, that has already been broken. That is what breach of a condition. In that case, any other customer can claim for the damages which he may get suffered from. That is about the breach of a condition. And always remember, warranty comes lateral to the condition. Condition comes first and then comes warranty. Moving ahead with this. Okay. Now there are certain express conditions and implied conditions. Express conditions means any condition which is already attached, which is completely communicated through the terms of contract, the terms of the pointers which are mentioned in the agreement, like point 1, 2, 3, 4. So these are all express conditions which are mentioned maybe on a pamphlet, maybe on a package, which are listed there and which are associated with all the parties involved. When I say all the parties, these parties are seller and any buyer who is involved in that particular transaction. Implied conditions, there are certain types of implied conditions which we are going to see one by one. Okay, so the implied condition is it's basically which presumes the existence of any terms of a contract. So it is presumed basically. So the condition as to title, whatever is the title, it is expected by the buyer that it is as per the title. Like Parle-G biscuit. It's as per the title. Okay. This is a simple example, and we are going to see all these implied conditions one by one here. So first one is as to title. In case of a sale, the person has a right to sell the goods, and in case of an agreement to sell, he will have to right to sell at the time of property to pass. So in short, the meaning of this is whatever the title of the goods is, he should sell it as per the title, whether it is sell or agreement to sell. If it is agreement to sell, he should sell it with the title at the time of property is going to pass. Why? Because agreement to sell is going to happen in the future as per the agreement. So whenever it is going to happen in the future, at that point of a time, it's the duty of a seller to sell the goods as per the title. Now, sale by description. Description which is mentioned on any product, or maybe description during the advertisement, description during the demo is given about the services or the product. The description is like about the quality, quantity, characteristic, features, any other thing of some about material, about the measurements, anything which is given to you in the description or the details. You expect that the actual product which or the actual service which you are going to avail is as per that only. Okay, that is implied condition. Then sell by sample. It may happen that sometimes we need a bulk quantity, and for that bulk quantity we obviously are not going to check each and every item, but we ask for the sample. And it is again presumed that the sample which you have seen, or the sample which you have got in terms of the demo which you have got in terms of for particular services, it is as same as the bulk which you are going to receive, right? That is sale by sample. Then implied condition as to fitness and a quality. So again, the concept which we just saw, that is about Cavet method. It's a buyer's awareness to check if the product is particularly fit for your requirements, if the goods supplied are reasonably fit for all your purposes. It's not mentioned in the contract, but still it's your responsibility to check whether it is fit or with a particular quality as what you expected about. Okay. Then as to mercantability, so the goods which are going to sold by the seller should be of mercantable quality. Mercantable quality means um, they should be in a state that it should be sold. There should not be any kind of damages, there should not be any kind of defects, there should not be any kind of any other issues due to which it is not in a condition to sell, but still the seller is selling that particular product. It should be mercantable quality, and it should be as per the description. Then implied condition as to wholesomeness. Now this particular condition is related mainly with the eatable and drinkables. So whatever food or drink we are buying for consumption, it should be free from any defect. It should be fit for human consumption, is implied condition. Obviously, whenever we go and visit any restaurants or any hotels, any place for eating and drinking, we make it sure that the food which is prepared there is fit for our consumption. Okay, moving ahead with this, implied warranties. First is quiet possession. Quiet possession as in buyer shall have a quiet possession of a goods. There should not be any other attached conditions with that. Once you have done with the transaction, once you have given all the required money and have fulfilled all the conditions, you should get a possession from it, right? Freedom from any kind of encumbrances. So the goods you are availing, it should be free from any extra charges, any damages. There should not be any kind of damages. That is again implied warranty. And it is the duty of a seller. The third implied warranty is it is the duty of seller to disclose, to explain if there is any kind of danger related with the goods or services which is going to availed by the buyer. So just say like Cavet method is from the buyer side, but sellers, it is also seller's responsibility to disclose everything if there is any kind of a dangerous nature or danger related with the goods or service. Okay, moving ahead with this. Okay, that's great. Now here I am going to explain you one case which is related with the Sale of Goods Act. Now this is the actual case of which I have took from one of the case laws. Okay, I am going to read this case here, and in the next slide itself we are going to discuss it. Okay, this case was an actual case where the the appellant means who appeals for the case. The appellant company sold a certain number of forging machines used for killing mosquitoes to the respondent, that is a corporation company, for which the payment had to be made within 1 week of a delivery. Now what is happening here? The company who sold certain number of forging machines to another company, for which they need to make a payment within 1 week of delivery. Okay, what is the next point? The respondents did not pay within 1 week. The company to whom those forging machines was sold, in short, who is a buyer, did not pay within 1 week. Okay, now respondent did not communicate with the appellants with respect to the payment afterwards. The meaning of this is the buyer who needs to pay after 1 week after receiving those forging machines, he should pay it within the 1 week, but he didn't pay, and even he didn't communicated with the company from whom or to the seller about the payment afterwards. But what happens later? After 6 months of using the machine, the respondents communicated with the appellants. That means buyer communicated with the seller, but only to complain about the forging machines inefficiency. They said that the machines were defective. What happened here? Seller sold those forging machines to buyer. It was expected from buyer to pay within a week of a delivery, but buyer didn't pay within a week, and even they didn't communicate with the seller with respect to the payment. But after 6 months, what they did, they came back to the seller, they communicated with the seller and complained about their forging machines inefficiency and said that they were defective. So in a way they are trying to they are not accepting basically those forging machines after 6 months. Now, because of all this, the seller, that is appellants, have filed this suit means case, to recover the payment of machines from respondents, means from the buyer. Now, the question here is whether the respondents are liable to pay for the machines. Are they responsible? I just raise your hand and then I will call the name. Whether the respondents means buyer are liable to pay for machines. Anyone is ready to answer? Just raise your hand. Yes, Zubieda?
Yes, ma'am. I think they are liable to pay for the machine
Can you explain why?
because the fault is from their side, right?
But
The
what is the
fault is
fault?
in the
You are right. You are
just 1
going
minute.
right. I just need the
Yes.
actual answer. Yeah.
Yes, because the fault is with the production, right? It's a manufacturing defect, right?
Okay. Okay. Got your answer. Moving to the
Yes.
next student, Vinayak.
Yeah, good evening, ma'am.
Yes. Good evening.
First of all, there is a one condition that there is a make that within a 1 week delivery they make to make a payment. This is the first condition. And without any payment, they are using the machine for 6 months. So this is the second thing that made the law that they are without any communication for the payment and they are using the machine. So so this their responsibility that they are not making the payment to respondents.
Hmm.
So if any losses done,
Hmm.
that may be their end only.
Yes, correct, correct. So in short here, if this whatever seller has sold forging machines to the buyer, and if buyer would have made the payment as per the agreement within a 1 week of delivery, and here it is also expected that the buyer should check all the forging machines whether they are working or not at the time of delivery itself, right? Both things have not done by the buyer, and that's why once the seller has once the seller has filed the case against the buyer for recovering the payment of machines, he is liable to pay for the machines to the seller because of his two faults. First one, he did not pay within a week as per the contract. Secondly, he did not communicate about it to the seller. And thirdly, after 6 months, he is mentioning about the inefficiency, which he should done immediately if there was any problem, right? So this is all about the case, and the same has been mentioned here in the in this slide itself. Okay, but here in this slide all the pointers have been mentioned in terms of sections, which you can read here. Like section 42 is about valid acceptance. So in a short, there was acceptance from buyer about the forging machine, that's why he got the bulk amount of forging machines, right? Section 32 is about the payment, delivery are concurrent conditions. So once the payment should be done after the delivery, that is about the section 32. And the court is eventually held that the respondent, that is the customer, is at a fault in a law for the non-payment. So basically non-payment is not acceptable in any kind of a contract in this selling and buying activities under the contract of sale. Okay, moving ahead with this, I am going to ask you one poll question here, and I want all of you to quickly answer this. This is a very simple poll question. We have gone through this concept 2-3 times till our discussion, whatever we have done. So buyer should reasonably examine property before purchase and take responsibility for its condition along with its quality and need. The concept is named as dash dash. Don't get confused. We have discussed this many times. I'm just going to keep this poll open only for 2 seconds. Please mute your voice. Okay. Now I'm going to end this poll and share with you all the results. Friends, you can see here that many of you have still got confused. The first 4 word itself is saying everything about the concept. Buyer should reasonably examine before purchase and take responsibility about condition, quality, need. Answer for this is a doctrine of Cavet emptor. Let the buyer be aware. It's buyer's responsibility to examine about everything, about the goods, services, its quality, its need, its purpose, everything before he go for a purchase. So the option number 3 is the right option. Okay. Moving ahead with this. Next module is about Consumer Protection Act. So whenever we think about consumer protection, all of us are consumers. The one who is going to consume any product or services for his own purpose is not going to sell it further. Then it will be called as a reseller, then, or it can be called as a customer. But the consumer who consumes goods or services for his own purpose. Now, in this particular act, we are going to see rights of a consumer. The first right is obviously a safety. Whatever goods or services we are going to use, it should be free from any hazardous to life and a property. It is the right of us to get informed all about the quality, quantity, standard, price of the goods and services. Any kind of protection is required. All these should be properly informed. Right to choose from variety of availability in the market of any kind of goods or services. So nobody, no seller, no company can enforce you to buy their own products because of something. So as a consumer, you are having the right to choose from variety of available products and services. Right to be heard if you are facing any sort of a issue about the purchasing the products or services. It's your right to get heard or to be assured that customers' interest will receive the due consideration at the place of buying and selling. Right to satisfaction of a basic needs, whatever goods or services we are availing, it's a basic right to avail the basic services, essential services. Okay, simple example, all of us are facing a hit right now. We are all of us are going through summer season, and we all of us are trying to be at the place where we can calm ourselves. Like we are trying to on the ACs, fans, all these things are there which fulfill our basic needs. Okay, then right to satisfaction, sorry, right to redressal. Redressal as in if we are suffering from any kind of unfair trade practices or restrictive trade practices, or any kind of exploitation has been done on the part of consumers, then we can ask in the court for redressal of all those practices. If any kind of fraud has been done, if any product, if any company is selling any product with a wrong information, with unusual information which is not actually there with with the product or service, then we can ask in the court of law for those particular redressal. Right to consumer education. So consumer education, there are certain norms which are prepared to make all the consumers aware about their rights. Like they can file a case, they can ask for the compensation, they can ask for the information required. All these are their rights, which again is another right for the consumer education. Then right to healthy environment. So wherever they are availing any goods or services, it should be safe, it should be clean and healthy and at the sustainable environment. Simple example of wherever we at the weekend we visit the malls. So it should be safe, it should be clean, healthy and sustainable, right? Right to file complaint from anywhere. You can file a complaint online or offline. You can file a complaint through video conferencing. The particular class of a consumer should be protected. Then if your complaint has been rejected, you are also having the right to ask the reason behind that rejection. Okay, so these are all the rights of a consumer. This is a Consumer Protection Act. So from all those rights, you might have got an idea that why basically we are learning this particular act, right? So the basic objective is the consumer should get a protection and strengthen their the group or class of consumers. They should have a right to dispose of all the related disputes, or all the consumer disputes should be settled properly. There has to be proper process to resolve all these disputes, which we call it here as a consumer grievance redressal process. So there are certain authorities, there are certain councils who look for this sort of redressals or settlement of disputes. So deploying certain those mechanisms or processes for disposing of all those complaints. And if there is any kind of pending cases, those also should be get again disposed of. And it is going to work throughout India. These are certain important definitions. First is a complainant. Now, till now, whatever we have gone through, and based on that, immediately you can think that complainant should be consumer only. But this is not the case. Complainant can be anybody from this. So listen to me carefully. Complainant can be a consumer, obviously. A complainant can be voluntary registered consumers association. So it's a group of consumers voluntarily registered themselves. It can be central or state government. They can also act there as a consumer in certain cases, or it also can be central authority, or one or more consumers in a case of all of them have same rights. Like if the group is coming together, even if they haven't formed the association, still they are coming together for some similar interest. Okay, or it can be any legal heir or representative of the consumer. But in which case, if the consumer's death or if the consumer is of a minor age, then in that case, that consumer's parent, its guardian, all these people will be considered, or all these groups can be considered as a complainant. Basically, in a consumer court, the person or the group of people who are filing the case or who are placing the complaint about some specific issue will be considered as a complainant. Consumer, as I said earlier, the one who is availing those goods or services for self-purpose. That availing of goods or services can be through offline mode, online mode, through tele-shopping, multi-level marketing, direct selling, or any other modes. Deficiency, to what you can say deficiency, there is some particular damage, there is an imperfection, there is a fault in the service, there is inadequacy which is not as per the details mentioned on the product or service, there is negligence by the seller, there are certain omissions or commissions while giving you the information which cause the loss or injury to the customer. All this will be called as a deficiency, under which you will be able to get a consumer protection. As I said, these are certain mechanisms or councils which helps to resolve the cases. Central council, state council, and district council. Obviously, central council is at a central government level. State council is as a state government level. District is at a district level. So central is all these basically are advisory councils. They give advice to resolve the cases. For the central council, there is a chairperson. This chairperson is ministry in charge of Department of Consumer Affairs. For state council, there is also a chairperson who is ministry in charge of consumer affairs in state government. For district council, chairperson is a collector of the district. All these three councils, for central, they should meet at least once. State council, they should meet at least twice. And district council, they should meet at least twice again. But all three, if required, anytime, should meet and resolve the cases. Okay. So these are all the consumer protection councils, and their basic motto is to give advice to resolve the cases related with the promotion and protection of consumers' rights. Please mute the voice of the student. Then these are certain more redressals, again related with the district, state, and national commission only, or we can say central commission. Central is located in the capital region of national capital region, which is held by one president and minimum of 4 members. A state commission is established at a central location, state capital, again, which is having one president and minimum of 4 members. And district council is established as per the direction given by state government, whether it is at a particular district or at a particular city or a metro city or whatever. They will be having a one president and minimum 2 members. Okay. So district will follow, and even state council will follow all the rules given by central government, and district will handle all the complaints which are coming to them. State commission will resolve all the cases, but within the umbrella of those goods and services who are getting or who are running their businesses within 1 crore to 10 crores. And more than 10 crore related complaints or the goods and services who are running their more than 10 crores, those complaints will be filed to National Commission. Okay. Moving ahead with this. There is a mediation cell who is at a 3 levels, again district, state, and national level. There is some noise is going in the background. Can we please that? Please mute the voice of student. Okay, thank you. So state government consumer mediation cells, they are again at each district and state commissions. Central government is only running for national commission related with all their other branches, and the number, their qualifications of all the members, presidents will be prescribed by state, central, depending upon the case, whether it is about central commission or the national commission. Depending upon that, mediation cells, their members, their qualifications will be decided. Moving ahead with this. This is a product liability. Okay. Now, in this case, we are talking about consumers. So, which kind of defects or which kind of things and who will be kept liable for that? Who is that fault basically? Who is at the fault? So, in case of product manufacturer, he can be held liable for obviously manufacturing defect which he has made during the manufacturing, and if there is any kind of defective design itself, if the manufacturing design itself is not as per the conformance, and if there is any kind of absence of adequate information and the usage of the product he has not particularly mentioned it, in all these cases manufacturer will be held liable. Service provider will be held liable if he is making any fault, imperfection, deficiency, inadequate in terms of quality, nature, and manner of the performance. He is not giving the proper information. Either he is omitting those information or giving something extra to sell the product. In that case, he will be held liable for, and because of which, if the consumer is suffering from any harm, any losses, then after that, the seller will be held liable, which is maybe some another level of distribution channel. He will be held liable for alteration of modification of the products, which was already some another design is there, and for selling it from another point of view, he has made some alteration in that, and because of which there are some certain more faults with that design, and it may be harmful to the consumer, and all these cases he will be held liable. Okay, so this is a product liability. There is a certain second poll question for all of you. Again, it's a very simple. I'm requesting all of you just read it carefully and then answer. I have launched a poll here. Who selects the members of the mediation cell of the National Commission? Quickly answer. This is again a bit tricky question, I would say. Quickly answer. Is it Vice President of India, President of India, Prime Minister of India, President of Commission? Who selects the members of mediation cell for National Commission? Okay, and now I'm going to end this poll and share the results with you. And I'm happy to see majority of you have given the right answer. That is answer number 1. There is no role of Vice President or President of India or Prime Minister of India in this. There are all these 3 commissions are going to have a president, and which members to be selected will be in the hand of President of Commission only. Moving further with this, here we are going to start with our third module, that is like module number 9, intellectual property rights. So again, the name is saying everything, intellectual property rights. So all those things which are created or which are created out of intellectual mind of the creator, right? Like if we imagine any logo, it's intellectually created from any human being, right? Or we can think about any musical notation, again it is intellectually created, right? Or we can think about some story which is written by a particular writer which he has created by his own. So these are a lot of examples. Okay, intellectual property rights are basically protection of those intellectual properties which are created by a specific particular creator of that, right? So it can be anything like design, it can be any poetry, it can be anything to which as a creator you want to get a protection, and out of that you may get some monetary benefits, but it depends on creator to like person to person or depending upon the company to company. So starting with this, the first intellectual property right is obviously a patent. Patent is divided into 2 types, utility patent and design patent. Utility patent prohibits individuals or company from like using it, making it, selling it without taking authorization or without taking permission. It can also be called as patent for invention. So this was invented for the first time, and if any other person wants to use it, he cannot use it without the permission or authorization of the owner of that patent. For that, he has to buy that patent, right? Design patent, it's a design of anything which is having all the visual qualities in that particular manufacturing item and the manufacturing design, and is having legal protection for that. It's a design patent. Okay. Now, the extension of this patent is varied from country to country. This may be extended from 10 years to 20 years. In our amendment of 2005, we have got extension up to 20 years as well. In all other areas, in all other countries, this extension varies. In short, this particular patent can the question is basically here, to which thing you can call it as a patent. The conditions given here are novelty, inventive step, and industrial applicability. Novelty is something, it's the whatever is created, it is for the first time. It is not yet published or presented anywhere. It is not yet disclosed anywhere till now. It's completely inventive. It's giving some technical advancement to, or it's giving an additional step towards the knowledge or towards the significance of economy. And because of that, it is applicable to in the industry for certain this kind of invention. Okay. If all these three conditions are applicable, then only your creative or the thing which you have created unique will be patented. Okay. Moving ahead with this, another is a copyright. We all are aware about this. Copyright is basically related majorly with the literary work or dramatic work or cinematography or musical things, sound recordings. All these things comes under the copyrights. So musical notations can be copyrighted. This now in this case, owner can assign this his copyrights either partially or wholly. So like for example, musical notation is there. Some of the tune can be copyrighted. Okay. Or he can copyright the whole musical notation like that. So it is available only for the work of original creation. It is not copy pasted anywhere. It's a original one. But still we generally, but it is not again mandatory. Okay. It is not applicable to ideas, but to the form of expressions or to the form of ideas. And that's why sound, music's artistic work is attached here. Okay. This copyright is not necessary to register, but it is advisable. So there are two rights or two types of protection. The first one is economic right, obviously for reproducing or reusing those particular work or performing that work in particular public area for the performances. Then you give that particular protection. Or moral rights, out of which you restrain any other person or claim for damages if he is using your copyrights without your permission, or he is doing any mutilation out of your work. In that case, you will get a protection there. Then is a trademark. Again, it's very similar word to all of us. Trademark is any kind of a trademark. All the companies which you are using for their logos, for their name, for the color combination which they are using, for the label, for the packaging which they are creating out of it. Like a simple example we can give here: various types of biscuits. Each of them are having their own different packaging, their own different logos, right? Even simple say the different brands in the market for say car owners who are coming up with a new design, maybe the electricals or all those things. They're having their own logos, they're having their own trademarks for the certain things which they have created. Again, for a trademark, it is not compulsory to register, but it is advisable so that any other company is not going to use it. If it is used, the person can file a case against you, right? Or the owner of the original creator can file a case against you. So the definition of the trademark I would like to read here is, it can be any sign that individualizes the goods of a given enterprise or a company, we can say, distinguishes them from the goods of its competitors only. So this trademark can be brand name, visual symbol, signature, name, label, packaging, logo, picture, or combination of all these, the parameters which I have just gone through. This is a trademark. This trademark can be divided into two types: certification mark and collective mark. Certification mark, certification mark is something like for specific standards. If we achieve that, those kind of a standards, like as I mentioned here, ISI mark, ISO mark, if the company is able to reach to that standards and they get certified for that particular standards, which measures the origin, material, mode of manufacturing, performance of services, performance of all the employees or the workers who are working there, and based on that they get certified as a competent. Then is a collective mark. Collective mark, the simple example I have mentioned here is the CA mark used for chartered accountants, DR mark used for doctors. Then there is a signature sign particular for all the advocates, right? So this is a trademark, or we can say this is a particular collective mark which is used for number of members to make themselves different from all other associations, or this is a collective group coming together and they are making their own collective mark, and which is registered again. Geographical indication is another in the intellectual property rights. So geographical indication is an indication which helps to identify that particular geographical territory with some unique name, with some unique symbol, based out of some quality or some goods or some services which they are providing. Examples I have mentioned here: basmati rice, if that particular basmati rice is tagged with geographical indication, it's a identity that it's India's aromatic basmati rice in a national international market. Then Kashmir saffron, it's from Jammu Kashmir. We can easily identify that, and there are a lot of such examples which we can easily identify. So this is an indication which is due to the intellectual property rights, and it identifies that geographical area with a particular products or services, which gives them a uniqueness to that geographical area. Moving ahead, industrial designs, obviously all those industrial designs which are helpful in the form of some formal or ornamental appearance with a mass production, which satisfies the needs of consumers through all the ways, like appealing, visually appealing it to the potential customers. Then it's giving all the required services, all the required needs to the consumers. This is coming under the industrial designs, basically any aesthetical design. So in short, when we think about the Tata Motors Harrier car, right? So immediately we go and check for all the aspects, aesthetical aspects of that. Then again, internal things like so how much it is spacious, and whether it is electrical or the petrol or the diesel, and what are their other specifications, what are the unique features that particular car has got. All those are aesthetically we check, and that is the industrial design which is unique. All the, like, number of cars we daily see, number of cars are coming in the market day by day, but every car every company try to make something unique with their cars, right? So that is industrial design. There is a third poll question for all of you. I hope you all are able to understand and enjoying this session. And there is one poll question to you: GI tag will be provided for dash dash products: agricultural, natural, manufacture, all of this or none of this? Very simple question. Quickly answer. Okay, majority of you have answered this now. I'm sharing the result. Still, I can see some of you have got confused, but majority have given the right answer, and the answer is all of this. GI tag is basically what? It's a geographical indication tag. So that geographical indication is basically through some unique products or service of that geographical area, and you are getting identification through that in the market. So that particular product can be anything. It can be agricultural, it can be natural, it can be manufactured. The example I gave you about basmati rice, the example I mentioned about just this Kashmir, what? Saffron from Jammu and Kashmir, right? So these are some simple examples, but all these three can be considered under GI tag or any other things as well. Okay, moving ahead with this. Yeah. So now here we are going to start with the Companies Act. How many of you are entrepreneur here? Just raise your hands. Or who are having their own companies? Just raise your hands. Anyone? Or majority of you are from the employees side? How many of you are employees in the company? Okay, so majority I can see here as a company who are working as an employee. No worries. But how many of you are aware about why we are learning this Companies Act? I just want an answer in the chat box. Just type yes or no. Are you aware that why we are learning this Companies Act? Just type yes or no. Okay, Prerna, can you explain why you are learning this act? Prerna? Prerna, quickly answer.
कंपनी को कंपनी कैसी चलनी चाहिए इस हिसाब से कंपनीज एक्ट 2013 किए वाला है.
Okay. Vinayak Kakade, can you answer quickly? Vinayak Kakade, why we are learning this? Are you aware why we are learning this act?
Yes, ma'am. There is actually some laws are there companies reacting. So कि कैसे कंपनी को चलाना चाहिए and what are the companies actions for related to design, related to for manufacturers, everything is there for in companies act.
Okay, great. Now my next question before moving to the next slide. Just mention in the chat box the types of companies you know. Just mention in the type box quickly the types of companies you know, you are aware. Okay. Okay. I have asked only types of companies. Some of the options I have got very related. Private, public,
Public
partnership, LLP. Yes. So majorly it is divided private, public, limited, unlimited. Perfect, perfect, perfect. Very good. So in this act, we are going to see the types of companies in short. Okay. The answer which I asked you for the first question was why we are learning this act. To any company before or even they have started running their businesses. It is mandatory for every company to register themselves under the Companies Act. Okay. For that registration, they need to have with name, then their registered office, then the number of members who will be starting with the company, along with that some stakeholders, the amount of capital they are going to invest, right? Am I right? Just mention yes or no. Am I right?
Yes,
The amount of just mention in the chat box. The amount of capital they are going to invest, Whether it is if it is a partnership company, how much shares they are going to invest in the company, right? If it is public limited, number of members. If it is private limited, number of members. How the company is going to run. Some of you have given me this answer. So how the company is going to run? It is like some rules, regulations, some policies which should be created. Again, those policies should be registered somewhere so that all the employees are going to follow this. All these things should be mentioned at the time of registration of your company under Companies Act, and that is what the purpose of this act. Okay, it is not for only for all of us only to listen or only to understand this act. Just now, whatever pointers I have mentioned, this is the reason why we are learning this act, and this is the reason why the act is basically there. Okay, so all the listed and unlisted companies from India will be under the Companies Act. Because of Companies Act 2013, the transparency was got increased in the all the transactions of the companies. They made it mandatory for corporate social responsibility. They made it mandatory for timely approvals of all the required documents, revision of all the intervals and disclosure about all the required information, approvals of all the shareholders. All these parameters started doing in the Companies Act 2013 during the amendment of the Companies Act. The concept of company, like for which thing we can say this as a company. First of all, it should be an association of number of people who are coming together for the specific purpose. Generally, that specific purpose obviously is first to get a profit, and secondly, of something providing some service or manufacturing some goods or trading, whatever it is, there has to be some common purpose between those people. It can be an association of maybe more than 100 people as well. There has to be limited liability. That company, once registered, will be treated as a separate entity from all the members who are involved there. At the time of incorporation, that means at the time of, like, it's a startup. So at the time of first registration of that company, there has to be at least minimum 7 members or 7 persons involved. For public limited company, if it is a private limited association, private limited company, then minimum 2 persons should be there. After registration, it will be treated as a separate legal entity and in the artificial legal entity in the eyes of law. It means whatever operations will be performed on the name of company, they will be performed from that company name only. There will not be the name in the front of all any kind of a members. Okay, like company seal will be used, company's VP, whoever the stakeholders are there on the name of company itself, they all will be doing all the transactions. So there will be separation of all ownership and management. Okay, there has to be transferability of shares which will be transferred to others for some particular consideration. Even though the members are going to join, newly joined, some members will get out of the company if there is any kind of a death or any other things even happened. Company is going to be there till it is dissolved, till it is completely winded up. That is called as a perpetual existence. There is a common seal, which I just explained. All the transactions will be happening through the official signature of the company. And if all these parameters are followed properly, then that will be called as a company. Okay, moving ahead with this. As just now you mentioned about the types of company. Statutory company is there, registered company is there, public limited company is there, and private limited company is there, which some of the part we have already discussed out of it. For public limited company, they can freely invite all the public for subscribing or contributing among the equity capital. But for private limited, it's a private company, it's restricted with some membership. That restriction can be limited or unlimited with some particular liability, or it can be limited or unlimited with some shares or the guarantee. As just discussed, limited or unlimited liability, it's not incorporated for profit making. Limited by shares or the guarantee, it may extend to the amount of shares contributed towards the company. Or unlimited, it may or may not have some share capital contributed, but owing to the nature of their activity, they are not investing any money, but they're invested above the activity of that particular work. Private limited and public limited, the difference is mentioned, which first difference we already discussed. In case of public limited, at the incorporation, there has to be minimum 7 members involved. At the time of private limited, there has to be minimum 2 members involved. Okay. Now, this again private limited. So there is a restriction of members. So it can be from number of 2 members to 200 only, not more than that. But public limited, minimum 7 to any. Raising about a capital, public invitation will be given in the form of subscription to the capital through which they can invest themselves in this public limited. In this case, public invitation subscribe for any securities only of the company is prohibited. Transferability of shares in public limited, it can be freely transferred to the public, but right to transfer share is restricted in the articles of private limited only. So when I say articles, it's the rules and regulations of that particular company, which is registered. Okay. So all these are differences in this. Then this is again an important concept under Companies Act, lifting of corporate wealth. Corporate wealth is nothing but a protection given to any or the whoever is the number of members or promoters or managers or shareholders who are working or who are running the company and the background on the name of the company. So this may happen that as company is treated separately as a legal entity, right? They are treated, company will be treated separately, and on the managers, promoters, shareholders, they are running that company in the background on the name of the company. Okay, so XYZ company limited is there. We can see only the name of the company. It is not always possible that we know all the promoters, managers, shareholders of that company. We know only the name of the company. It may happen that there is some misuse of the funds, there are certain frauds, there is certain issues with the transactions. Okay, and who is doing all this? Only the members who are involved in the company, and they are hiding themselves behind the name of the company. They are doing all this on the name of the company. If any court found this, if any please mute your voice. If it is found by any court, then they can lift this corporate wealth. It means they can lift this protection from those promoters or managers or whoever involved in this particular kind of activity, which should not be done on the name of this company. Okay. It may also happen that because of some certain fraudulent activities, companies is going to wind up their all the proceedings, so that all these certain fraudulent activities will be stopped. In short, if the court found that there are certain fraudulent activities, any frauds or any uncertain actions are being done on the name of the company, they are going to lift this corporate wealth. They are going to lift this corporate protection from all those members who are doing all these activities. Moving ahead, formation and incorporation of a company. Formation, it's like first promotion. Just think about it, like you have a startup. You are the promoter who are coming up with the business idea. So with that, you are having certain list of instructions, certain affairs of the company, like how it is going to run. You have advised some board of directors to run your company, and you are prepared with the first we can say draft of the company registration. After that, you need to make a registration of your company as a promoter. So what is the next process you are going to do is you will be thinking about the name of the company. Then as a promoter, you will assign or you will register the name of the company with the registrar of the companies. and get the certification from the registrar. For that, sorry, you need to fill up form 1A as mentioned here. Apart from that, you also need to prepare with some legal documents which is advised by some maybe advocate or legal expertise. Along with that, you also need to draft memorandum of association and articles of association, which I'm going to explain you in next few slides. Within 60 days, right? Within 2 months of from getting the approval of your name, the promoter should apply for registration of company, and once registrar is satisfied with all the documentation and the information, registrar is going to give you the register, and is also registrar is going to give you certificate of registration, certificate of incorporation, and is going to mention the details of company in his own register. Okay, that's like book of registration. Okay, so this is the process of formation and incorporation of any company. Similarly, for online registration, similar process is going to be done, but through online mode. You have to come up with the memorandum of association, articles of association. You should be with named with the director, who will be the director, who will be the manager, and who will be the secretary. You should be ready with all the members, their signatures, their addresses, and all those details. Now in now cases, we need to ready with Aadhaar card, PAN card. All those details should also be there. So the similar process which can be done in an online mode as well. Memorandum of association. At the start of this act itself, I mentioned about all these parameters. So whenever we are going to register our company, we should be ready with our name of the company, which should be unique. If it is public limited, we can attach only limited word. If it is private limited, we attach pvt.limited company. We should be ready with the registered office. Okay, so the registered office should be again with a particular address where all the communication will be given to that address only. You should be aware and should write in that memorandum of association the purpose of starting up with your business. Why you want to do this business? What is the purpose behind it? What will be the actual activities will be undergoing through this? What will be the public policy? What will be the specifications? And also it should not be illegal. All these things should be mentioned. How much amount of capital you are going to invest? What is, if it is partnership, what will be the shares of capital which will be divided under all the partners? Association, like the number of members who will be involved at the time of memorandum of association, at the time of registration of company, and liability, unlimited, limited liability. All those things should be properly mentioned under the memorandum of association. Okay, moving ahead with this. Articles of association, as I mentioned earlier, articles of association is nothing but rules and regulations which helps any company to run the business successfully. So these articles of association, either the members of association can write on their own, or they can take help of articles of association, or we can say the format of articles of association which is already there under the Companies Act. Okay, they can take the help of that and they can make a modifications as per their requirement. They need to submit these articles of association to the registrar along with memorandum of association at the time of registration. All these pointers, all the specifications which are mentioned in the articles of association should be agreed by all the members involved in the company and should be followed by all the members involved in the company. Then the prospects, obviously it's a document which is published with the required information so that investor can invest their certain amount in terms of capital to the company. It's a document which helps to make an offer of selling of some equities to the public and invite the investors to invest in their company. So that is about the prospectus. There are certain rules made by the SEBI for that. Membership, you can get a membership of any other company by getting a subscription to that company. Now, in this case, every other member who in a writing agrees to become a member, and whose name is entered at the time of registration of the company as a member will be called as a member here, or any other person who is holding number of shares of that company can also be called as a member. Now, what will be the rights of that member? He can transfer the shares, he can call for the meetings, he can he will be having the rights to vote or accepting or rejection of any kind of resolutions. He can call for the voting of shareholders in general or ordinary meeting. So all these are general rights which any other member is going to have of any company. This is the concept of shares again. So share is like equity shares or preference shares. How many of you are aware about this? Preference shares or equity shares? Just mention in the chat again. Just mention in the chat with what you know about this. Yes, anyone? Just mention in the chat.
Ma'am, can you repeat again question, please?
My question is, what is the meaning of equity shares and preference shares? What do you know about it? Yes, obviously it's in the company only. Equity shares are also voting rights. Okay. Both are offered by the company. So basically, share of equity capital, these are contributed by any members, okay, who are involved in the company. They can contribute themselves in the form of shares towards the company, and in return they get a certificate of shares that they are holding certain rights in the form of shares towards the company. For equity shares, those who are holding equity shares, they are going to have a right to vote for certain resolutions. They can participate in certain decision making. They can declare certain dividends from the profits. This is all about equity shares. And preference shares are like whatever the amount of the money you have invested in the form of shares, only for that percentage or only for that particular amount of dividend, you will be involved in any kind of a transaction. So that is fixed. Out beyond that, you cannot make any kind of you are not going to have any right over any other shares out of the amount you have invested. That is the difference in this equity shares and preference shares. Here is a poll question for all of you. Quickly answer. Again, this is very simple question which I have discussed. I have taken a lot of time to discuss this. Quickly answer. Yes, quickly answer. Okay, the majority of you have answered this. I'm going to end this poll now here. And I can see some have got confused, but majority have given the right answer. And the right answer is option number 1. Option 1 is what? Separate personality of the company as a distinct legal entity than that of a persons behind it. The persons behind it means to whom the persons are going to be behind the company, and the company is treated as a separate legal entity. So the company is, just imagine, this is the company who is a separate legal entity, and this is run by all the people who are running on the name of that company. Okay. For example, XYZ person is a manager of dash dash company. So he's running the company for that particular domain, being the manager of that company. So it's a separate personality of the company as a distinct legal entity than that of a person behind it. Understood? That's why option number 1 is the correct option. Moving ahead with this. Yes, we are moving to module number 11, Right to Information Act. Again a question. Are you aware why we are learning this? Quickly answer in the chat box. What is the right to information? My second question is there. What is the right to information? Just mention in the chat box. Which information you want? Please answer fast. Which information you want? About services? Yes, it's a rights given.
Ma'am, experiences of expiry date.
Can be anything. Just mention in the chat box. Information about related to our surroundings. Okay. Everything about organization service. Okay. Yes, Vinayak Kakade.
Actually, madam, it's transparency to buyer and seller both.
Yes. Yes. So it's a transparency about any any services, right? Can you give any example about out of it if you have answered it properly? Can you give any example, Vinayak?
Ma'am, transparency means if any order or anything to your written, so that's the purchase order is there. So it may be a transparency to the legal and with the employees also.
What will
So
happen
that's
if
the
you
right.
don't get the information? What will you do?
If information is on not on time, it's not on right. If you are not giving any answer to the sellers or buyers, so it's some legally means जो अभी हम कुछ भी हम करेंगे तो उसके लिए एक्ट हो जाता है कि आप अगर राइट इंफॉर्मेशन नहीं देते हो कि बायर के लिए या सेलर के लिए.
You can ask for the reason, basically.
Yeah.
Right?
Yeah.
Okay. So it's the same thing we are going to see here. Right to information is basically that as a human being or as a general public, we are having a right to ask for any required document, record, notes, any certificates, any kind of important information of any organization, their duties, their functions. We can ask for it wherever required. Okay. The example which I would like to mention here, which we discussed in some another batch. Okay. The example is some XYZ person was trying to give some examination, and 2-3 times, even after doing very good studies, even after getting a lot of efforts, he got failed in that. And after investigation, he found that he got failed because of some uncertain reasons. He didn't selected in some particular competitive examination in short. He was trying to find out the investigation. Through investigation, he was trying to find out it by asking a lot of information, and he didn't got the required answer. Okay. So in this, it may also happen that some certain public authorities, some certain public authority companies may have their own disclosure, because of which they cannot disclose some specific information to all the public, but those information which should be given and it is the right of a public, they can disclose it depending upon case to case. Okay, but how you can approach to ask for the information? Just through a written application to the public authority. And what will be that public authority? State Public Information Officer, who deals with all such sort of request of information. With that, whatever the minimum amount is there, generally just 10 rupees, which will be paid to accounts of officer to that public authority will be paid, and you can ask for the information. Okay, but it is not compulsory to mention why you need that information, why you are seeking that information. It is not compulsory to provide reasons for seeking the information. If you didn't get the information, you can appeal first to the appellate authority. If appellate authority is still not able to resolve your case, you can appeal to the State Information Commission. And this is what the process happens. First, the application. There is a time limit that after making an application within 30 days, you should get the information. In certain emergency cases, in certain life and liberty related cases, you should get the information within 48 hours. You should pay the required reasonable fees, but fees are again not applicable to the people who are below poverty. And if the information is rejected, you are having the right to ask about that. But if the public authority mentions that it is not in the disclosure, we cannot give you that. We cannot force again for that information. That is all this process talks about. These are the information officers, we can say authorities, which works for that. Central Information Commission, State Information Commission, they both are having chief information commissions. Central is just chief information commission is there. For state chief information commission is there. For central, there are 10 more central information commissions are there. Again, for state, maximum 10 state information commissions are there. There is certain committee for both commissions, central and state, which consists of Prime Minister as a chairperson for central, leader of opposition in Lok Sabha, who is Union Cabinet Minister, will be nominated by Prime Minister. In case of State Information Commission, the Chief Minister will be acted here as the chairperson of the committee. Again, there is going to be involvement of leader of opposition in Legislative Assembly and Cabinet Minister to be nominated by Chief Minister. Headquarter of Central Information is there in the Delhi. For state information, it will be decided by the headquarters by particular through notification. And this is basically chief information is obviously going to run all these activities till he attains the age of 65. If in certain cases, maybe earlier of that. Similarly for State Information Commission. The powers they are going to have is to get the complaint, to resolve the case, to disciplinary action against the information officer if he is not resolving it in time, to impose penalty on him, and to conduct the inquiries which are related with the denial of information regarding extra payment of fees for getting the information, if there is any misleading information given to the one who is seeking the information. All these things will be inquired by this information commission here. There are appellate authorities who will be helping to resolve the cases related with the information related acts. The first, this is basically two-tier appeals. First is public authority and second is information commission itself. If the public authority, first appellate authority is unable to resolve, then you can appeal to information commission, who is there, who will be appealed by Central Information Commission only. Penalty will be there, like 250 rupees each day till the time the central information or state information is furnishing that particular information to the required person, and this total amount should not exceed 25,000 rupees. It will depend upon case to case. Okay, so here's a fifth poll question to all of you. Quickly answer. This is a very simple one. It is not compulsory to provide reasons for seeking information. It is not compulsory to provide reasons for seeking information. True or false? Don't get confused. Yes, majority have answered it. And I'm ending the poll here. I can see half of answers here. Some of you have answered it true and some of you have answered it false. This line is from the PPT itself. It is not compulsory to provide the reasons for seeking the information. If you are applying for getting some information, it is not mandatory to write for the reason why you need that information. So the answer is true. It is not compulsory. Okay. Moving ahead with this towards the next module here. And the next module is module number 12, which is a combination of variety of acts, starting with different forms of business organization. sole proprietorship, partnership, and company. About company we have already discussed in our Companies Act. So I'll be covering here the partnership and sole proprietorship. Sole proprietorship is obviously a business who is start by an individual who is taking the whole risk of profit and everything on his own. He's investing his personal assets for as a business, liabilities for running the business. His business is not a separate legal entity because he is only the one who is handling all the operations. Or the only thing is he should follow all the legal formalities under the legal framework of which is mentioned as the Companies Act. The simple examples of this sole proprietorships are any kind of household personal services, professional firms, retail shops is the best example. Partnership where two or more people come together with a specific purpose to start with the business, and they decide the amount of capital to be invested and amount of profits to be shared by all or whoever is involved under the partnership with the percentage or the ratio which will be divided for carrying out all the business activities. That is what the partnership, again it's a legal relationship where they have to agree upon some certain terms and conditions and they need to make a contract of the partnership. Moving ahead with this Partnership Act, just now we were discussing about. Okay, so the definition is just currently I told you, association, two or more people, but maximum number of partnerships should not be more than 50 participants, and they should carry some specific business and the motto should be profit of the business only. As I said, they should come up with some particular contract, an agreement. So in that agreement, which we call it here as a partnership deed, this partnership deed covers all these parameters. It should cover the name and address of the firm. It should cover name and address of all the partners who are involved in this transaction. Nature of partnership business, like what kind of activities will be going on under the partnership. Commencement and duration of the partnership, whether it is for 1 month, 2 years, or throughout the years, which we are going to see in the next slide. Partners capital, interest on a capital, profit and loss sharing ratio, accounts audit. If wherever they are going to dissolve the partnership, what will be the process of that? All these parameters should be mentioned under the partnership deed. Which is the written agreement about their all the terms and conditions. Partnership at will. These are three types of partnership. Partnership at will, where there is no duration specifically mentioned in the partnership deed, or we can say agreement. It can dissolve at any time by any partner, but before dissolution, the partner who is willing to dissolve it should give a priorities to another involved partners in a writing. So they should give a notice, basically. It may also happen that any partner can give a notice and retire from the partnership, and there is not any bound or limited by the period of time. Particular partnership, they have made this particular partnership for a specific purpose. Once that purpose is fulfilled, their partnership is dissolved on completion of that purpose. Partnership for a fixed period of time, like as I said, it can be 1 year, 2 year, or any other fixed periods. Once that period is completed, their partnership is going to be dissolved. Another act in the Miscellaneous Act is Competition Act. So the Competition Act basically it's promoted by India, our government, to promote the welfare of the consumers, to have the healthy competition in the economy, which will again foster the growth of the economy. There should be certain policies to make this competition. There should not be any unfair competition. It should utilize all the resources available in the market, which will help healthy competition, which will boost the growth of the economy, which will have a welfare of all the customers, so that all the consumers can avail their required services, can go for their required products, and can have fulfill their all the basic needs and all the requirements. That is what the purpose of this Competition Act. There is an involvement of Competition Commission of India will be looking for all those whether all these parameters are running smoothly or not. This is established by obviously central government of India, which will be consisting of a chairperson with the 6 members of that central government only. They will be functioning as a market regulator for preventing any kind of anti-abuse practices practices, anti-competition practices. Competition Appellate Tribunal is again attached with this Commission of India, which is a quasi-judicial body, which is established for the purpose to dispose of any cases related with the competition with the help of Competition Commission of India. Another act, information technology. All of us are majorly using information technology. All of us are using lots of information through online modes only. So it's online documents, it's online signature. The point here is whatever the things we are using through electronic exchange, through electronic interchange, through electronic communication, all this should be properly protected and should get a legal recognition for all kind of information and transactions we are doing in an online mode or electronic mode. That is the objective behind this act. So when we talk about legal recognition of electronic documents, it should be in the electronic form. It should have a proper protection to that electronic document. It should be accessible to make a use of that, but with some protection again. That can be attached with a digital signature. So nowadays we affix the digital signature for authentication of any electronic document, which can be any even simple Word document as well. It can be any simple PDF, but again it is protected. We can see that, and then all the things have been decided under IT Act 2000 only. Okay. E-governance, again, all of us are majorly known with this word, which helps in reducing the corruption, which helps in overall reducing overall general cost, which has brings any access or delivery of government services, quick and efficient resolution of all the communication, the efficient use of ICT, which all of us are required. This is basically government plan to cover the quality of information and give proper services to all the general public in effective and efficient manner. And this was the purpose of e-governance. Digital signature and electronic records, which already we have discussed. As I said, electronic records can be anything. It can be Word document, it can be general spreadsheet, digital images, anything which we are using in an electronic mode. And digital signature is the electronic signature which is used for authentication of those electronic records. There are certain certifying authorities who looks for authentication of all those documents which we are using on electronic modes. They grant a license to issue these electronic certificates. Their primary purpose is to either issue, to cancel, or to renew these digital or electronic certificates required for this specific use of protection. There is an involvement of controller of certifying authority, that is CCA, who will be running by these certifying authorities, and the responsibility of those CCA is to basically ensure that all the provisions written in this act are not violated. They are properly followed by the parties involved in this. That is what the role of CCA mainly. Then comes Negotiable Instrument Act. So the word itself is actually very big. In general, negotiable instrument is basically any kind of instrument which we use for any monetary transactions. So when we say monetary transactions, you can even see the words here: promissory note, bill of exchange, checks are generally we use like for doing any kind of monetary transactions. This is a kind of promise we are making to the person to whom we are making the payment. I will give you the payment and with this particulars. So bill of exchange which comes with certain list of items which you have bought from certain shop or restaurant for which you are going to make a payment. That is a bill of exchange. Check, which can be open check, bearer check, cross check, any kind of a check. All these things are negotiable instrument which helps us to do some negotiations in kind of monetary transactions, and it's a promise to pay to the person with whom you are doing these transactions and transferring money from one person to another person. Okay, then these are all the pointers which I just mentioned. Only with particular sections we have mentioned here. So section 4 talks about promissory note. Section 5 talks about bill of exchange. Section 6 talks about check, and section 13 is the complete definition of negotiable instrument. Check we already discussed. Bill of exchange is the one who writes the bill and gives it to the another person to whom the money, from whom the money should be paid to the owner of that particular product or service. Promissory note is again written by one person as a promise to pay certain sum of money to the person to whom you are going to give the money. Okay, that is the promissory note. Check, already we discussed about this, and these are general definitions in terms of law language. It's already written here. As I mentioned, the types of checks are open check, cross check, bearer check, or order checks. Okay, then comes a Minimum Wages Act. So Minimum Wages Act, this is basically to give protection to all the workers to get the minimum wages or minimum amount of wages which will help them to survive, which will help them to get the minimum amount to survive, or to we can say to basically to fulfill their basic needs like food, water, shelter. These are the basic needs of any human being, so they should get at least that much amount. Okay, so these all the wages have been fixed by, prescribed by a wage committee. There are two methods of fixing this minimum wages: committee method or notification method. Committee method, where the committee members sit together, they make certain recommendations and they finalize the amount of minimum wages. Notification method, official, through official gazette, government decides and declares the rate of minimum wages. Like that, minimum wages runs. Code on minimum wages. This code on minimum wages again has been this is designed by the Ministry of Labor and Employment, that has been introduced in the Lok Sabha. The purpose behind this code on wages again to regulate all the terms, conditions, all the norms which are related with the wages and bonus for throughout the country, related with any industry, trade, or anything. This pointers covers the wages related things, which covers the bonus, which covers the reduction from the amount, which covers the normal working day, any kind of the amount which should be given as a overtime. All these parameters should be are covered under the code on wages, and which is followed by all the industries, trades, business, and manufacturing company. Uh, when we talk about bonus, minimum bonus should be of 8.33%, maximum bonus should be 20%. Then the payment or the salary or wages should be given to equally to all the workers or the employees who are working at the same level with the same skills, efforts, and experiences. All these parameters have been mentioned under the code on wages. Factories Act, when we're talking about Factories Act, establishing a factory means itself is a the people who are working in any kind of establishment who is running for manufacturing process specifically, and who are having 10 or more persons employed in that particular factory will be called as a factory. And it can be on running year, that is current 12 months, or preceding in the last year they are having this manufacturing activity. Factories can also be considered if there are certain provisions for the Factories Act which are related with the health, safety, and welfare measures of the workers. Then employment of women and young person, whether to employ on certain machines or not. Some, if there is any kind of accidental or occupational diseases, what will be remedies for that? What will be working hours, annual leaves of all the workers? Compulsory approval and licensing of all the factories is required. If there is any kind of dangerous, what will be the next provisions for that? All these provisions are mentioned under the Factories Act. It should be followed by all the factories, which covers under the Factories Act. Women compensation. In short, compensation should be given to all the workmen who are working in the company and who have met with any accident or there is a death of that worker. For that, they should get a compensation. Okay, so in what cases they should get the compensation? In case of death, the employer worker dies on account of accident. In that case, their heirs or their representative family member should get a compensation. Permanent total disability, if the worker has lost his all the capacities of earning because of that accident. Temporary disability, he has lost certain period, he has lost the capacity for certain particular period, like he has got admitted, then he got recovered. That is temporary disability. Permanent partial disability, it's earning capacity of the worker has reduced partially. So all for this, there are certain amount of compensation has been mentioned. In case of death, 50% of monthly wages or 80,000 rupees, whichever is higher. Permanent total disability, 60% of monthly wages or 90,000 rupees, again whichever is higher. Similarly, for permanent partial disability, 60% of 90,000 rupees will be given as a compensation. For temporary disability, half monthly payment of the sum equivalent to, like whatever is amount he is getting as a monthly wages, calculation will be 25% of that, and monthly payment of that 25% will be given to that person who has suffered from temporary disability, but for the period of 15 days till he recovered from that injury. And this is on these, all the compensations are calculated on the basis of monthly wages only. They will be going through all the injuries, what kind of injuries they are facing. If there is any kind of identical injury, if two or more workers have faced, but again, still based on their monthly wages, the compensation will be given to them. This is a personal data bill. Again, the motto, or we can say purpose behind this personal data bill is to give a protection to all kind of data we are using currently on all kind of social media. Like we all are using Facebooks, Instagrams, and a lot of other social media platforms, right? And we even don't know, majority of us might not be aware that which data is there shared with which companies or which platforms, right? Because we are accessing many times many platforms, many forums, and many things. So that's why the India has applied this personal data bill. Okay, the purpose for this is a protection given to the personal data and privacy of individuals, and specifying where the flow and usage of personal data will be. Then creating the relationship between the persons and the entities as which I mentioned right now, the forums processing the personal data, which can be sometimes again hacked, which can be misused, for which you can file a case against, right? For all those things, there are certain authorities under this protection, this personal data bill, which have established the Data Protection Authority of India for these all the purposes and for resolving the matters related with. So these are all certain definitions which comes under personal data. Okay, the data is obviously any kind of data which we are using, right? So it can be any personal messages, social media transactions, it can be any history, browse search history, it can be any identification numbers which is used by any of us. And then data processing, it can be any raw data which we are using. Okay, any kind of raw data which we are using, any kind of useful information, patterns, trends which we are using to access any kind of information. Data principal, this is a person who is there to collect the data and to process the data. Data principal is the person who is there to collect the data and process the data. Data fiduciary is entity, separate entity who is entrusting all this collection and processing of the data. This is interesting. This is ensuring that there is no any misuse of collection and processing of that data. Data processor can signify two things, like referring the third party entity to whom the data fiduciary gives data processing, and refer to physical machine where that data has been sent, has been stored, and is processed, and has been converted from raw into useful information. So whatever data we are mentioning on an electronic format, they have in background some certain coding, right? And it can be converted in any form. So this is what data processor is doing, whether it is going in a proper way or not. Personal data, it's your personal data, any kind of codes, your passwords, your traits, characteristics, anything. Sensitive data is your sensitive data, which you majoritarily, we should not disclose on certain platforms, like it can be genetic data, health related data, sex life, caste, tribe, religious data, anything which may be sensitive to the world. Right to data portability. So the data principal has the right to receive the data, personal data, in a structured format and in a machine related format, readable format. Right to be forgotten. If the data principal is having the right to restrict the data, to discontinue, to make a use of that data for any further person, which is making the misuse of that. Okay. And as I said earlier, Data Protection Authority of India is there, who is looking for all these functions which are happening under personal data protection, and who is responsible for protection of personal data of any person in our India. Okay. Data Protection Officer who works under Data Protection Authority of India, who looks for any grievances and auditing or recording of any related information. Adjudicating Officer is there, who is having to call people for making inquiries for fiduciaries, for any compliances. Appellate Tribunal is there. If any case is not covered by adjudicating authority, you can approach to appellate tribunal. So that is again a 2-3 tier machineries to resolve the cases related to personal data. So this was all about personal data bill. I am posting here the last poll question here. I want all of you to quickly answer this. The third party entity that processes data is called, question here itself is having answer with it. Quickly answer. The third party entity that processes the data is called, great. Majority of you have given the right answer. I'm just sharing the results here. The right answer is data processor, the entity which processes the data, right? He is the person who processes the data. It's called as a data processor. He processes the data in a readable format, right? So here we are done with all our modules. Okay. So I want all of you to answer our survey poll quickly. And I request everyone to, if you have any questions, to just mention it in the our Canvas inbox, which where I can read all of your questions one by one and can answer it there itself. Okay. Just answer this survey poll quickly. I hope that the concepts which I have tried to explain in all these 6 modules, I tried to give it a proper way. Even if you are not satisfied, I request all of you, whatever questions you are having, please post it in the Canvas inbox. I will answer it there itself. There is a second poll question. Please answer this. Kindly quickly answer before leaving. From the concept point of view, this is a legal aspects of business. This is a bit related with the law. Some concepts you may find it difficult to understand. And that's why if you can mention in the Canvas inbox the concept name, I will be able to explain that. The last poll question is here. Thank you very much, Vilas. Please quickly answer. Only half of you have answered it yet. Thank you very much, Nitin. Thank you, Gnaneshwar. Thank you, all of you. As I mentioned again, please mention your queries in the Canvas inbox. Okay. Thanks, Gangadhar. Thank you very much. I'm just ending this session now and will be.
Ma'am, I do have a question.
Okay.
Since you covered model 1 to 6 in the first session and 6 to 12 in this, are there going to be any more sessions which you're going to take?
We conduct sessions, we post it on our Canvas calendar. Okay. And
Okay.
get a notification from there. So
So
try
each
to
module, are we
ensure
going to go deep further?
that, in this format only we try to go, because looking at the number of students and number of modules, we need to cover 6 modules in our one live session. So that's why I just mentioned, if you are facing any difficulty with any chapter or any concept, you can ask me there in the Canvas inbox. I will definitely try to resolve it there at that itself.
Okay. Okay, ma'am. Thank you so much. Yeah.
Thank you, madam. It was very interactive session, but what I feel personally, that the speed, you need to cover the all models. So can we divide it? Can we give that suggestion? So that, because we are not from the management side, we are trying to learn this new concept. So the content is very good. You means the lecturer, the person who are delivering that information is excellent, but the way we are getting, if you know that if all information, too much information we are getting in within 2 hours, so all brain will wash out all the
Yes.
information.
Understood. I will try to get back to you on this. I will need to talk with our management regarding this.
Yeah,
Okay.
means can we break it in 2 sessions? That will give us a good
Yes,
output.
yes. We'll
That is
try
what
to
I
do something about it.
But thank
Okay?
you very much.
But till then, keep in mind, you can ask your questions in the Canvas inbox. Okay.
Thank you.
Yeah. Thank you so much. Thank you, all the students. I declare here
Thank
the
you,
end
ma'am.
of the session. Thank you.